Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie LeBenz. Today we are going to talk about settlement options if you're facing a divorce or a legal separation case. So in previous videos, we talked about trying to settle before you file. We've talked about trying to settle after you file. And this is talking about settlement options if you haven't been able to settle prior to this point. And also you've had the opportunity to go through discovery, disclosure, you have a bunch of information, and theoretically, both sides should have sufficient information to start negotiating. So we're going to talk about what are your options once you've gotten through disclosure, once you've gotten through discovery, how can you try to settle your case and avoid going to trial? Well, of course, we've got two types of cases. We've got with or without minor children. So if you're facing a divorce or a legal separation without minor children, then what is on the table to settle? Well, first of all, you've got to settle the division of your property. So whatever your marital property is, you're going to need to figure out the division of that property. And then if spousal maintenance is at issue in your case, what's the amount to be paid per month? For how long would it be paid? And then is it modifiable or not? And then resolving legal fees and costs if that is at issue in your case. If you have a case that involves minor children, then you have property division, you have spousal maintenance, but then you also have legal decision-making, sole or joint, your year-long parenting plan, and then child support, the amount of child support, who's going to pay for medical insurance for the kids, how are you going to divide uncovered medical expenses for the kids, and how are you going to divide the child tax exemptions? So, and then of course, legal fees and costs if that's at issue in your case. So additional issues to resolve if your case involves children. Whether you have a case with or without children, the options for settlement are the same. First, you could negotiate directly between the parties. You can seek to try to resolve your case at a resolution management conference. You can try mediation, which could be private or through the court. And then there's also the option of a judicial settlement conference. So let's start by looking at negotiations between the parties. It starts by making a written settlement offer with a deadline. From there, you can negotiate. And if you reach an agreement, then you'd put the terms of your agreement into a consent decree. So if you have no kids, you're going to put your agreement into a consent decree. Plus, if spousal maintenance is ordered, then you also need to do an income withholding order. Both spouses would sign the consent decree either before a notary or a court clerk. You would file the completed signed consent decree with the court. And when the judge signs and enters it, that's when you're officially divorced or legally separated. Regarding this income withholding order, if spousal maintenance is ordered, that income withholding order is an order to the spouse that's being ordered to pay spousal maintenance. It's an order to their employer to take a certain amount out of each paycheck to go to the support clearinghouse to then go to the spouse that's entitled to the spousal maintenance. So that's what the income withholding order is all about. And we will cover that form in today's class. Now, if you have a divorce or legal separation case with children, then there's a bunch more forms that you'll need to do. If you reach an agreement, you'd put your agreement into the consent decree, but then you'd also put the terms of your parenting plan into a parenting plan. The terms of your child support agreement would go into a child support worksheet and a child support order, and then you'd have the supporting income withholding order for that as well. Both spouses would sign the decree and the related papers before a notary or court clerk, file everything with the court, and once the judge signs and enters the consent decree, you are divorced or legally separated. Let's look at the consent decree form. So this is for Maricopa County. If you're doing a divorce, you check this box. If you're legal separation, you check the second box, and then with or without children. And this is a 21-page document, so it's long. So this is some of the standard language to show that you qualify for a divorce or legal separation. Check the boxes about pregnancy and paternity, protective orders. If any protective orders are involved, you put that information there. And then community property, either no, we didn't acquire community property, or we did, and the terms of our agreement are in Exhibit A. So I'll show you Exhibit A as well, but check the box that applies. Separate property, either you didn't acquire any, or there's an agreement to divide separate property and debt. Spousal maintenance, either no spousal maintenance or indicate who's entitled to spousal maintenance, the grounds for it. And then whether or not there are minor children, if there are, include their information about paternity, whether both parents have completed the parent information class, child support, whether or not there's been welfare benefits received, because that can trigger other things to come up. So you could need the written approval of the attorney general or county attorney. So you'd indicate that there, whether or not there's been domestic violence, drug or alcohol conviction within the last 12 months. And then legal decision making. Are you agreeing to joint legal? If so, you'd fill this out. And then parenting time, this is only for supervised or no parenting time. So if that doesn't apply in your case, you'd leave that blank. And then here are the orders. So legal separation or dissolution, either legal separation or dissolving your marriage. If wife wants her last name restored, you'd enter that information here. Enforcement of temporary orders, either not applicable or indicate what happened with the temporary orders. Protective orders, children, pregnancy, paternity, maternity. Again, you just fill all of this out. And then what is your agreement? Is one parent getting sole decision making? In the event, you'd fill that part out. Or are you agreeing to joint? Primary residence or parenting time, fill that out. And you'll also see here that this box here says reasonable parenting time rights as described in the parenting plan attached as Exhibit B. So I'll show you the parenting plan form, which we've gone through several times throughout this program, and that can just be attached as Exhibit P and then made part of the decree. Child support, and again, you're going to have this child support order is attached here to and incorporated by reference. So I'll show you the child support order. That also gets attached. Information about spousal maintenance, property and debts, tax returns, financial information exchanges. This will apply if your case involves child support or spousal maintenance. Qualified domestic relations order if you're dividing a retirement account or a pension. Any other orders. And then, of course, you leave this blank for the judge to sign. Here's where both parties sign before a notary or court clerk. And then here's Exhibit A, the division of property and debts. So you'd put in here whatever your agreement is regarding the division of property and debts. So you'd fill this all out. Here's the section on real estate. This prior section here is on retirement accounts. Division of community debts. List your agreement here. Separate property, separate debt, list all of that information here, and then both parties sign if they are in agreement with all of those terms. Here is the parenting plan agreement. We've seen this form before. You can fill this out and submit it as Exhibit B to your decree if you have a divorce or legal separation case with minor children. So this document's 10 pages long. You just fill in all the terms of your parenting plan agreement in here. And then you both sign. And this would be Exhibit B to your decree. And then you could have Exhibit C being your child support worksheet. So of course, this is a blank one, but this would be filled out with the information from your case, and the final numbers down here would be the amount that you agreed upon for child support. And then there's the child support order. And when you fill out the child support worksheet, that's done in an Excel spreadsheet. And then there's an additional tab at the bottom of the Excel spreadsheet for the child support order. And you can find that, and that'll auto-populate with what you put into the child support worksheet. And then this form will come out. You can just read through it, make sure it matches up to what your agreement is. And this would also get filed with the court. And then this is the current employer information form. This is for Maricopa County, and this is for cases with minor children and for spousal maintenance. So this form must be completed for an income withholding order. And this is where you would put information about the party ordered to pay spousal maintenance and or child support. In Yavapai County and in many other counties, rather than do that employer information form, we fill out the actual income withholding order. And so here's page 1. It's a 5-page document, but this is the income withholding order, and you would just fill this information out about child support and or spousal maintenance. So it's 5 pages long. So let's just do a summary. What happens if you reach an agreement and your case does not involve children? You're going to put that agreement into the consent decree and also the income withholding order or employer information sheet if spousal maintenance is ordered. Both spouses sign before a notary or court clerk, and then you file it with the court. And once the judge signs off on the paperwork, that's when you're officially divorced or legally separated. And then if you have a case with kids, there's additional forms. You've got the consent decree, your parenting plan, child support worksheet, and the child support order. Also the income withholding order or the employer information form. Both spouses sign before the notary or court clerk. And then you file the completed signed consent decree, parenting plan, child support worksheet, child support order, income withholding order, and or employer information form. And then when the judge signs off on everything, your case is resolved. Okay, so those are direct negotiations and how to, take an agreement, make it formal in the paperwork, file it with the court, and have your case get resolved. Another option is the resolution management conference. The court will schedule a resolution management conference about 40 days after the response to the petition for dissolution or legal separation is filed. Both parties must file a proposed resolution statement 5 days prior to the RMC. If the parties reach any agreements, their agreements can be put on the record in a Rule 69 agreement at the RMC and made into a formal order of the court. So here's what the proposed resolution statement looks like for a divorce or legal separation case. You can see it's an 8-page document. You're just going to start filling it out with how you want your case to get resolved. So what do you want for legal decision making? What are you looking for parenting time, child support, spousal maintenance, separate property, community liens, community property? So all of that is going to be in here. Your tangible personal property, debts, attorney's fees. If you are the wife and you want your last name restored, you put that information here. And then any other issues, date and sign here. Of course, read through this paragraph first. And then this is your mailing certificate page. So that's the proposed resolution statement. If you reach an agreement, let's say you each file your proposed resolution statements and it shows that you both want joint legal decision making. Well, then at the resolution management conference, you could do a Rule 69 agreement where it's agreed that you will share joint legal decision making. And that Rule 69 agreement is binding if it's in writing and signed by the parties, if the terms are stated on the record before the judge, or it's stated in an audio recording made before a mediator or settlement conference officer appointed by the court. The court still has to approve the agreement for it to be final. And then if after the agreement is reached, the Rule 69 agreement is made part of the record and the judge approves it, either side could challenge the validity, but it's really tough to win on that. And a party who challenges the validity of the agreement has the burden of proof to prove the defect in the agreement. And you could get ordered to pay the other side's attorney's fees and costs if the court doesn't find that your reasons for trying to challenge the agreement are valid. Next, let's look at mediation. You can do private mediation, or there's a mediation that the court offers, and mediation is voluntary. So nobody's required to participate in mediation, and all discussions and communications that occur in mediation are confidential. You can't use those later at trial. And the mediator can't share that information either with the judge. The mediator just gets to tell the judge when the mediation's happening, and what the outcome was. And also if anybody failed to appear. So what can be talked about at mediation? The parties may privately mediate any issue and dispute. The parties need to take care of the cost of a private mediator. The parties can ask the court to select a mediator from a list of private mediators they provide if they're unable to reach an agreement on that. And then they'll need to make sure that they pay the mediator. The court can decline mediation if it appears that mediation is inappropriate because of parental unfitness, substance abuse, mental incapacity, domestic violence, or other good cause, or because mediation will cause undue delay. So if your if your spouse is requesting mediation and you don't want to do it, then you'd be looking to object on one of these grounds, because the court can decline mediation under one of these reasons. The court needs to consider domestic violence, make sure everybody's going to be safe and not intimidated. The court needs to let both sides know that they can waive mediation, and the mediator can decline to mediate or can terminate mediation if the mediator determines that domestic violence makes mediation inappropriate. If your case has been sent to mediation and the other side hasn't responded and you're looking to file for default, you're not going to be able to file for default until the mediation's concluded. After the court has entered an order or referral to mediation, the mediator will schedule the mediation. Each party must attend the mediation or any conferences that the mediator sets. The mediator may permit persons other than parties and their counsel to attend or participate in mediation if those other persons agree in writing to be bound by the confidentiality rules. And counsel for a party may be excluded only if the party and counsel agree. However, the court-ordered mediation policy may authorize the exclusion of counsel. If a party fails to appear at mediation, the mediator must report that to the judge, and the court may impose sanctions. The court will not continue a scheduled trial or hearing based on a failure to complete mediation unless a party shows good cause for the continuance. The mediator has the option of ordering the parties to do a mediation statement prior to the mediation, and it's a confidential document. It just goes to the mediator. You don't share it with the other side, and it is not filed with the court. It only goes to the mediator. So the mediator can require each party to submit a mediation statement before a conference, and that mediation, let's see here. The court may impose sanctions if a party fails to do so. If a mediation statement is required, the party must submit it to the mediator, but you don't file it with the clerk and you don't give it to the other side. It's just between you and the mediator. So the mediation statement must include the following information along with any other information required by the mediator. A general description of the issues in dispute, the party's position on each issue, and the evidence in support of their position. If the issues involve financial matters, then a current affidavit of financial information, a list of outstanding debts, and the party responsible for each debt, and an inventory of community or joint assets, including dates of acquisition, amounts of encumbrances, and present values. A summary of negotiations the parties have previously had, and any other information that the party thinks will be helpful to resolving the case. So the mediation statement would have these 4 parts, and you would explain your positions, your point of view on each of those 4 parts, and then you'd submit that just to the mediator by the deadline. You can reach a binding agreement at mediation. For it to be binding, each party has to enter into it voluntarily without threat or undue influence, and after full disclosure of all relevant facts and information. The parties have to agree to the agreement being final and binding. The agreement has to be fair and equitable. And if the parties have minor children in common, the agreement is the best interest of the children. The parties must notify the court when the mediation is concluded and advise the court of any agreements that fully resolve their issues. The parties must provide this notice not later than 10 days after the mediation concludes, but also not later than 10 days before the date set for a trial or hearing. If the parties reach a partial agreement or no agreement during mediation, the mediator must file a brief report to the court. All family law cases that involve a dispute over legal decision-making or parenting time are subject to mediation through the court. The court must determine whether mediation or alternative dispute resolution services are appropriate in a particular case. The court or conciliation services may deem mediation inappropriate because of parental unfitness, substance abuse, mental incapacity, domestic violence, or other good cause. So both the judge as well as the conciliation services department can say, nope, this case is not appropriate for mediation. If there's a disagreement between the parties concerning legal decision-making or parenting time, either both parties may file a motion or request mediation, and then an order for mediation may also be made on the court's own motion. So the court on its own can send the parties to mediation, or either parties can request it separately, or they can make a joint request. Any agreements reached as a result of mediation must be in writing, and the parties must sign the agreement, and their attorneys, if any, must sign or object to the agreement within 30 days after the mediation. But the court retains final authority to accept, modify, or reject a mediation agreement, or to set a further hearing on the agreement. Here's what the form to request mediation looks like. So this would be if you want to request it without your spouse, you're just making an independent request. Here's the form for that in Maricopa County. Or if you and your spouse are in agreement to try mediation, here's the form for a joint request. And then once that's filed, the court issues this order. So with your request, you also file this proposed order. And then if the judge grants the request, the judge will fill this out and then sign it. Okay, so we talked about direct negotiations. We talked about a resolution management conference. We talked about mediation. And now here is the fourth and final settlement option that we're going to discuss today, which is a judicial settlement conference. On a party's motion or on its own, the court can order the parties to attend a settlement conference. If the parties agree, the assigned judge or commissioner may conduct the settlement conference. So generally in this context, the judge will ask the parties, do you agree? Do you want me to be the settlement judge or a different judge? In some counties, it always gets pushed to a different judge. Some judges always push it to a different judge, but sometimes there's the option of having the judge assigned to your case be the settlement judge or using a different judge. So that will often come up. The court may order the parties, their attorneys, and any other person who the court deems necessary to facilitate settlement of the issues to attend and participate in the settlement conference. The court may enter an order setting the date for the conference. The court may enter other orders that facilitate the settlement conference. You appear in person for that. If you fail to appear, the court could issue sanctions. The settlement judge may require each party to submit a settlement memorandum before the conference. And this is the same exact thing as the mediation memo. What is supposed to be in it is exactly the same, and the process is the same. It just goes to the judge. It's not filed with the clerk, and you don't provide a copy with the other side. Same thing as the mediation memo. And in it, you give a general description of the issues in dispute, your position on each issue, and the evidence in support of your positions, your AFI, a list of outstanding debts, an inventory of the community assets, and how you want them to be divided, really. What is your requested outcome? A summary of negotiations and any other information the party believes will be helpful to settlement of the issues. Communication with one party. If the court determines that it will facilitate settlement and with consent of all of those participating in the conference, the court may communicate with one party during the conference outside the presence of the other parties. If there's been domestic violence, the court needs to put reasonable procedures in place to protect the parties. Any binding agreement that's reached at a settlement conference can be made into a binding agreement through a Rule 69 agreement. And each party will need to enter into that agreement voluntarily, without threat or undue influence, after full disclosure of all relevant facts and information. Each party intends the agreement to be final and binding. The agreement is fair and equitable. And if there are minor children, then the parties need to agree that their agreement is in the best interest of their minor children. So again, if the agreement's in writing and signed, The court can accept that. If the agreement stated on the record through the Rule 69 agreement before a judge, that can make it valid and binding. Or if you state it in an audio recording made before a settlement conference officer appointed by the court, that can all be ways to make an agreement valid and binding. Of course, it's subject to final court approval. And if you're going to try to challenge the validity of an agreement after you've already signed it, or it's been put on the record through Rule 69, or it's been made into an audio recording before a settlement conference officer, then you will have the burden of proof to prove any defect in the agreement. And if the court doesn't think that your reasons are sufficient, you could get ordered to pay the other side's attorney's fees and costs. So it's really hard to get out of these types of agreements. So just keep that in mind. Let's look at a motion to set a judicial settlement conference. So here's a form I made. You fill out the parts in red, and this is where you're indicating that you'd like the court to set a judicial settlement conference. Here's your mailing certificate page. And then anytime you file a motion, you're going to file a proposed order with it. So here's the proposed order setting judicial settlement conference. Again, you'd fill out the red parts, and then you'd leave this all blank for the court to fill out and for the judge to sign. Here's the mailing certificate for the proposed order. And then if you are ordered to do the confidential settlement conference memorandum or the mediation memo, because the form's the same, this is what it looks like. So fill out your caption, and then you'll see here, here's the 4 different parts, A, B, C, and D that are required under the rule. So you would just tailor this form to your case to provide the judge with all of the needed information. Okay, we have reached the end of today's recording. So just as a summary, if you are facing a divorce or legal separation case, you have a couple of different settlement options. Number 1, you can try negotiating directly between the parties. If you reach an agreement, you would put that into the consent decree and supporting documents. And then when the judge signs off on your consent decree and files it with the court, you are officially divorced or legally separated. You can try to resolve issues at the resolution management conference. If you're able to do that, that can be made valid and binding through a Rule 69 agreement at the RMC. You can try mediation. If you reach an agreement through mediation, that could be formalized through a Rule 69 agreement or a mediation agreement. And then there's a judicial settlement conference. And if you reach an agreement there, that can be made valid and binding through a Rule 69 agreement. If you do a Rule 69 agreement, after that's done, generally one of the parties will then put that agreement in writing and lodge it with the court, because you do need the final written decree to finalize your case. All right. Thank you so much for joining me today. If you have any questions, please bring those to the live Q&A.